In this lecture, the tutor walks through customary tenancies in Ghana as interests in land under the Land Act 2020. The focus is how these tenancies are created, what interests the tenant actually gets, the main types like abusa and abunu, the key rights and limits during occupation, and the main ways the tenancy can be terminated. The material is organized in a practical sequence. First, it anchors customary tenancy in Act 1036. Then, it explains formation by agreement between a holder of a higher interest and a grantee. Next, it clarifies that the tenant gets occupation, not ownership. After that come the main classifications, and finally the rights and termination rules. Act 1036 explicitly recognizes customary tenancies as interests in land. Section 7A frames them as contractual. They arise when a stool, skin, clan, family, or a person with allodial title, customary freehold, or a usufructuary interest agrees to grant another person an interest in land on agreed terms and conditions. A key statutory idea is the relationship. Someone with the superior interest is the grantor or licensor, and the recipient is typically described as the grantee or licensee at custom. The tenancy depends on that underlying superior title, so it's not a freestanding ownership right in itself. The cases explain the social function. In Akrafi v. Wairisi, the court described a common pattern. An owner with uncultivated virgin or forest land grants it to a stranger to work, sometimes indefinitely, as long as terms are observed. Mensah v. Blow emphasizes the owner's willingness to allow occupation and use as a defining feature. For creation, the general rule is grant plus agreement. The grantor must have a higher interest, and the parties must agree on terms. Crucially, mere physical presence on land is not enough to create a possessory title. Manu v. Ainu is cited for that point. Occupation alone doesn't transform someone into a lawful customary tenant. The material keeps returning to this. Customary tenancies are shaped by customary norms, but also by what the parties actually agree to. So when analyzing any dispute, the tutor would look for the customary baseline and then ask, what specific terms did the parties contract for? Once granted, the customary tenant generally gets an occupational or possessory interest, not ownership. Manu v. Ainu notes that under arrangements like abunu and abusa, ownership remains in the landlord. Mensah v. Blow reinforces that even long occupation over decades does not by itself make the licensee at custom the owner of the land. The interest can continue beyond the original grantee. It may pass to successors after death, and it may be transferred to another person with the licensor's consent. Mensah v. Blow illustrates this. The respondent's status as a customary tenant was recognized because her ancestors had obtained the grant decades earlier, even though she wasn't the original licensee. The material classifies customary tenancies in two main ways. One is whether consideration is provided, so gratuitous versus tenancy for consideration. Another is duration. Some are limited to a sowing season, some run year to year, and some endures so long as the tenant or successor recognizes the grantor's title and the tenancy hasn't been terminated. A customary tenancy can be gratuitous, meaning no tribute or tolls are required. The material points out that Act 1036 doesn't make consideration a prerequisite. Even where something is given, it may be symbolic, like a customary drink acknowledging the licensor's superior title. Dalvey Clue mentions 2 bottles of schnapps annually as acknowledgement. In many situations, the tenancy is for consideration. The agreed consideration can take different forms: money, a division of farm produce or its cash value, or even in-kind arrangements, such as giving rooms to the licensor, where building is involved. For agricultural land, abusa and abunu are especially prominent and are recognized in Act 1036's first schedule. Abusa and abunu are share arrangements. Abusa is typically a 1/3 share to the landlord, while abunu is a half share. The customary default often turns on who bore initial costs. If the tenant clears virgin land using their own resources, it's commonly treated as abusa. If the landlord bore initial farm-making costs and grants it to be maintained, it's commonly abunu. Importantly, the Supreme Court in Lamptey v. Fanier stressed flexibility. Abusa and abunu are mere terms, and there's no inflexible rule preventing parties from contracting out. So even if the tenant cleared virgin forest land, the parties could still agree to an abunu arrangement, and the courts may hold them to that agreement. Another tenancy for consideration discussed is dibi ma dibi. It resembles abusa or abunu in being a sharing arrangement, but the ratio is negotiable, and typically it's the farm or land that is shared after cultivation. Each party then harvests from their portion. Even then, the landlord's underlying title is not transferred to the tenant. The reason classification matters is that it helps identify the incidences, meaning the practical rights and obligations. For example, under a bunu, both parties share equally in proceeds. Under a sowing tenancy, the tenant's right is limited to that season. Beyond type-specific terms, customary law recognizes a present right of possession for the tenant during occupation. One major incidence is that the tenant's present right of possession prevents the licensor from granting the same portion of land to someone else while the tenancy subsists. In other words, the licensor's superior title remains, but the tenant's possessory interest blocks a competing grant over the occupied portion. A striking incidence is that the common law fixture maxim doesn't apply the same way. In Assay v. Anto, the court held that when permission is given to build or farm on family land, the house or farm remains the property of the licensee and successors. Atta v. Essen similarly rejected a landlord's claimed right to enter and take fruits from economic trees planted by the tenant. Customary tenancies can be terminated. The material highlights several routes: compulsory acquisition by the state, termination by the agreed duration, like the end of a sowing season, forfeiture, where the tenant denies the grantor's title, and termination for breach, such as failing to pay agreed consideration. For building-related tenancies, a special customary rule applies when the building falls into ruin. On compulsory acquisition, Mamuna Amudi vi Antwi is used to show the effect. Acquisition bars and destroys other estates, rights, titles, and interests in the land acquired. The material then connects this to nemo.quod non habet. Once the licensor no longer owns the land, they can't grant interests in it, and the customary tenancy is effectively displaced. Parties can agree on termination terms, but courts won't enforce unconscionable conditions. In Dow v. Clue, a clause requiring the tenant to vacate whenever the licensor demanded was held unconscionable because it could allow the licensor to demand possession right after the tenant invested in a valuable building. Natural justice and good conscience set limits. Termination can also follow misconduct. If the tenant denies the landowner's title, the tenancy may be forfeited, and Donker v. Asare is cited for the idea that the licensor may determine the license on short notice in that situation. Separately, because the tenancy is contractual, failure to meet agreed terms, like non-payment, can justify re-entry and termination. For customary licenses to build, Dow v. Clue states a specific rule. The licensee may occupy so long as the permitted buildings remain in existence, and the license determines the moment the building falls into ruin. After that, the tenant can't rebuild or make major repairs without fresh permission, effectively meaning a new grant would be needed. The material argues customary tenancies remain relevant. First, they provide access. People who can't afford to buy land can still farm or build and compensate the owner after earning benefits. Second, they protect landowners. When owners can't actively use land, placing tenants on it helps deter encroachment and the risk of losing control through adverse possession. To wrap up, customary tenancy in Ghana is a legally recognized interest under Act 1036, created by agreement on top of a superior title. The tenant's core interest is possession and use, not ownership, but with strong protections, like control of fixtures and economic trees they establish. The outcome in disputes usually turns on the parties' terms, the tenancy type, and lawful termination rules.